Hi everyone, I'm Hanovi Schoonover, the Training and Resource Coordinator for Redmond Consulting, and I'd like to welcome you to the webinar. Before we begin, for those who may not know, Redmond is a nonprofit organization that provides tribal technical assistance on a variety of programs, including but not limited to housing and homeless services, children and youth, and elder abuse. This ranges from policy review via email to site visits. If you are interested, you can contact any of us at the emails that are at the end of the presentation. Presenting with us today is Victoria Ybanez. Victoria is the Executive Director of Redmond Consulting and has been for 16 years now. She has been working to end violence against American Indian and Alaskan Native women for over 35 years. She has a depth of experience working closely with tribes in developing and implementing a range of responses to violence against Indigenous women and has conducted numerous site visits, facilitated sessions, and training for tribes for over the past 20 years. She's experienced working intertribally as well as within a tribe's local culture. She has done numerous amounts of coordinating and providing tribal technical assistance for recipients of the Tribal Governments Program, the United States Department of Justice, Office on Violence Against Women, also known as OVW, and she also developed Redmond's National Tribal Advocate Center, which provides 40-hour domestic violence training and 40-hour sexual assault training. And I will now turn it over to her.
Thanks, Hanovi. It's good to be here. Welcome, everybody. I'm glad you could join us. Just next slide, Hanovi. So because this is an OVW funded webinar, we have a disclaimer. This grant is focused on responses for urban Native programs and non-Native programs working with urban populations, Native populations. Next slide. So when I think about doing this webinar, what really comes to my mind in urban settings is the importance of really thinking about our Indigenous populations. And the reality in there is that oftentimes, particularly our non-Native relatives, are not quite aware of our urban Native populations. And as a result of that, the responses are not culturally specific for sure, but also ends up missing some critical aspects that could have a negative impact or unintended consequences on survivors of domestic and sexual violence. So myself, over the years, I've had the good fortune in the work that I've done to develop a couple urban Native programs that are responding to domestic and sexual violence. The first one was American Indian Community Housing Organization in Duluth, Minnesota, and then the second one here in Colorado Springs, Colorado, which is the HACIA Advocate Program. And the motivation for doing that is not that there weren't already existing services, but that there was a gap in those services and a limit in terms of some of the understandings. And so I'm going to spend a little time talking about some of those limits and talk about how we want to think about that and giving you more understanding about particularly the unique legal issues in there. Next slide. So when we think about intervention considerations, and I'm talking about our urban Native populations, that we really want to think about who our urban Native population is. And a lot of times people make the assumption or the mistaken understanding that there's a thought that an urban Native, the response for them is going to be exactly the same. While there's going to be some similarities, there's some different challenges in there. And one, as an urban Native population, we're historically underserved. And and in urban settings, we often don't have a culturally specific response. When we know that the culturally specific response is the strongest option that we have for healing and minimizing the negative impacts of trauma. And at the same time, we know that there's some unique legal issues that come into play. And I'll talk about that. And then also victim safety. When we think about victim safety, we have to think about it in a broader context. So standard as an advocate, as we think about victim safety, we think about immediate victim safety, about where she's at, what she needs, how to keep her safe at right now. And then we also think about a little bit longer term safety. And for our urban native populations, we have to think in a broader way, in a larger way, because of ties to reservations, because of some of the ways things will tie back to their homelands as a part of the way violence could have occurred. So that's not going to be the case for everybody, but it'll be the case for some. And when it gets missed, it actually complicates the risks and problems and challenges for a survivor that doesn't get it addressed immediately. Next slide. So when we think about urban legal, unique legal issues for urban native survivors, that we really want to think about the relationship, the unique relationship with the federal government. And a lot of people make the assumption that Indigenous people are another group of people of color. And on some level that could be accurate, but it's more than that. And it has to do with this unique relationship that our tribes have with the federal government. And so there's a sovereign domestic relationship between tribes and the federal government. And as a result of that sovereign relationship, it creates a whole different set of areas that we need to pay attention to. So within that sovereignty, we can see in the government to government relationship between the federally recognized tribes and the US government, we can see the result that there are many different kinds of laws that come into play that that doesn't happen in urban settings, but depending on where the violence occurs, it could play out. So say, for instance, a victim experienced the violence at their home reservation, either while they were on a visit or while they were living there, and then came to the urban center, the urban area to seek information and support. What happened on tribal land comes into play in that situation. And I'll talk a little bit more about that here shortly. But what I want to do is I'm going to go through a few major laws that impact Native nations and impact and how it impacts the way things work. And I'm going to focus specifically around domestic and sexual violence as major crimes in terms of the focus on it, and just know that it plays out in other kinds of way, but keeping it contained within the scope and the intent of this meeting. So next slide. So the first crime I want to talk about is the Major Crimes Act. So the Major Crimes Act basically it's major crimes. So it's basically instances of murder, kidnap, rape, and mayhem. And the major crime was passed back in the 80s, 1880s, not the 1980s, but back in the 1880s. And as a part of it, so listed on this slide, the first thing it says is the Supreme Court case Ex parte Crow Dog. What happened is that out in Lakota territory, there was a murder that occurred, and the person who was killed was a member of one tribe, and the other person, Crow Dog, who committed homicide, was a member of another tribe. And at that point in time, so prior to 1883, At that point in time, the two tribes went to traditional law and they reconciled that. So they created their own, they had their own form of governments, their own form of remedy for major crimes such as that. And as a result of it, the settlers in the area basically thought that was totally wrong. And actually, one prosecutor who had taught me about this, the Major Crimes Act, many years ago, she had said in one of the documents, it said that it was that by God, someone must die for this. So the settlers wanted Crow Dog to be punished and to be hanged as a result of this murder. And although the tribes had already came to a reconciliation between it, as well as Crow Dog's obligation to the other family to provide restitution for the loss of this life, which was a significant restitution because the life was valued quite high. So as a result of it, the case went to the Supreme Court. And in that case, it basically said that the tribes had the right to make the decisions about their own, about what happens on their own laws. And as a result of that, then it went to Congress. And in Congress, they made the law of the Major Crimes Act, which then basically states that for crimes committed by an Indian on native land, if it was a major crime, it followed federal prosecution. So it meant it took it out of the hands of the tribes and it went to federal prosecution. And as a result, the FBI and US federal court prosecutes for murder, aggravated assault, and rape, with some exceptions. And I'm not going to get into that. I'm not a big legal person, but I have enough framework to give you this information. So this crime, this Major Crimes Act plays out today. So when we think about sexual assault, aggravated assault under domestic violence and sexual assault, it will rise to a federal crime. And so where this is important for you working in an urban area to understand, if the survivor that you're working with, if that victim that has come into your office seeking advocacy services, you need to have a base level understanding of where that crime occurred, particularly if it's recent, because there's some other kinds of issues playing out. So you may need to be helping her connect back to her tribe to get support and resources to help her as a part of a case that may still be being investigated and moving into prosecution. So the fact that she's here, it could still play out. It doesn't play out for everybody, but it could still play out. And it could be, she could be a critical person to be involved in that case. Not that she has to be involved, because we always want to follow what that survivor wants. That's always her choice or his choice. But in the process, that person may want to, that survivor may want to talk to law enforcement, talk to the prosecutor, have communication about it. And as an advocate program, you may want to make sure that you have the means to be able to support that person in making that connection and following through on what that person wants. Next slide. So this is another one that, just a little historical context for it. Public Law 280 basically came into play as a part of policies back in the I'm kind of drawing a blank. I think it was like the 1950s to the 1960s. And as a part of it, there were a few different things that happened through that process of those policies. And one of them was Public Law 280. And Public Law 280 basically was, initially it was an experiment as a part of the federal government trying to figure out how to handle its responsibility with tribes. And this goes back to treaty agreements that happened many years before that continue to be in place. And the federal government wanted to transfer jurisdiction and try it out to see how that would work. So Public Law 280 was passed. And as a part of Public Law 280, it basically eliminated the role of the federal government. So when I'm talking about those major crimes, stuff like that, it eliminated it. So it transferred its jurisdictional authority to states. Not all states. There was just a handful of states that Public Law 280 covered initially, and then as a part of that, again, there was some reaction, because when Public Law 280 passed, it was a mandate that, one, it was unfunded for the states for them to take on jurisdiction on tribal lands. Most importantly, though, was that the tribes were never consulted in this. So it was having a direct impact on the tribes and how jurisdiction and how these crimes were affected for them, and being responded to on their tribal lands. But there was no consultation. So they had no voice in this decision. So as a part of the reaction to that, they went back and Congress made an adjustment to it and provided a period, or actually opened it up so that people could pull out of Public Law 280, like tribes could actually pull out and states could pull out, as well as tribes and states could opt in. So there's different states that are Public Law 280. And as we think about, some of those different states, just based on some of the folks that have registered to be on the call, I know that Washington State is a Public Law 280 state, and it's other states like Minnesota, parts of Minnesota, parts of Wisconsin, Nebraska, California, Alaska. And then there's other states. I think Oregon is also Public Law 280 as well. And then when I say a state, I'm not saying absolutely all tribes, because some tribes opted out and never participated in that. So the other thing that's interesting in here is that people think, oh, so everything's now going to fall under state jurisdiction. And the reality is, when we think about jurisdiction, is that even with Public Law 280, what it was a transfer of federal authority. It had nothing to do with tribal authority directly. So the tribal governments still retain their sovereign authority. So they still could exercise their authority to investigate and prosecute a crime that occurred on their land. And it's not double jeopardy if the state is doing it. But the challenge in here is that because it was an unfunded mandate, it actually created tension between the tribes and the states, because it put the states in the position, basically through the county law enforcement, to investigate crimes on tribal lands. And we still, at times, in some of the areas in different parts of the country, I'll hear from tribal advocates, and they'll say, yeah, our county law enforcement in the area refuses still to come onto tribal land. So it leaves this void if that relationship hasn't worked out. So there's been a lot of tension that occurred. And why it's important to know, so again, as an urban center, that when we think about survivors in our urban centers, one of the piece in there is that we have a lot of migration that goes on. People might live in an area such as Seattle or Denver or Chicago or Dallas even, in major urban areas. They may migrate in and come in and go to college, or they may come in for a few years for a specific job and then go back to their tribe for a few more years, or they may even come into the urban center for a few months for different reasons. Maybe they're seeking medical services or something like that. And so there's this movement back and forth. And so as a victim of domestic violence, it's important to know, as you think about it, like what is going on. So if they experienced domestic violence or sexual violence, and it happened on their homelands, it's going to be helpful for the advocate to know, because it can have an impact that's going to be a negative impact. Next slide. So this is part of the Violence Against Women Act. So VAWA, as a part of the passage of the Violence Against Women Act, as we know over multiple years, that VAWA has grown from its original authorization from back in the 90s. And I believe it was VAWA 2005 when Title IX, Safety for Indian Women, that section was developed in VAWA. And it actually is one of the pieces in there is that it lays out multiple different provisions to address safety for Indigenous people, and specifically within the tribes. And so one of the pieces in here I wanted to point out specifically is Section 905, is tribal protection orders. Is so that in 2013, with the passage of the Violence Against Women Act, we had a clarification of tribal protection orders. And I acknowledge this as a clarification because VAWA, Full Faith and Credit, we got that back in the late 90s. And as a part of that, it always contained, it always included tribal civil protection orders. And what we know over the years, and this was in 2013, where they offered clarification about full civil jurisdiction of tribal courts to issue and enforce civil protection orders over all persons. So originally with Full Faith and Credit, that was in place, and we had this whole pattern of jurisdictions not honoring a tribal protection order. We still know that today. I still hear advocates talking either in urban areas or tribal advocates where they're hearing about civil protection orders from the tribe not being being honored outside of tribal jurisdiction. VAWA 2013 clarifies it again specifically about tribal protection orders to make sure that people understand this really has to be accounted for. The other thing that Title IX did in 2013 is that it amended the penalty provisions for repeat offenders convicted of interstate VAWA crimes by expanding the definition of prior domestic violence or stalking offenses to include tribal convictions. So previously it did not say anything specifically tribal, which again went to that lack of clarity. So they were clarifying it. And interstate, when we talk about interstate, we're talking about they're crossing state lines. They're crossing jurisdictional boundaries. And so, so not just county and stuff, it's crossing state lines. And so we want to understand. So if you've got a victim who had experienced violence, say for instance on the Pine Ridge Reservation, and they're in Denver, Colorado, that's an interstate crime. That's an interstate VAWA crime. So they amended those penalty provisions, and that includes repeat offenders as a part of it. So next slide. So Full Faith and Credit. So I talked a little bit about that already. And one of the things that we know is as a part of Full Faith and Credit is that it really is about making sure that our protection orders are honored in the different jurisdictions. So if you get a protection order issued in a city, if you get it issued in a county, if you get it issued in the neighboring state, if you get it issued in tribal land, it needs to be honored. And the same thing, if you've got a city protection order, a county protection order, and you go to the tribe, it also carries the same weight. It's a protection order, period. It's got the full faith and credit of the federal law that basically it protects survivors' freedom of movement by requiring law enforcement and courts to enforce protection orders. One of the challenges is that tribes have not had the same kind of resources as other jurisdictions have had to enter protection orders into the national database. And as a result of that, what we see is that sometimes when a tribal, a citizen of their tribe has a protection order and they come into a different setting, such as an urban area, and an advocate doesn't understand this, then what they advocate for is requesting a new protection order instead of honoring the one that they arrived with. And I just want to acknowledge that really clearly. By doing that, what we are doing is we are actively working to diminish the sovereignty of our tribes by saying their protection orders are not valid. Instead of being a strong advocate and saying, hey, we have a protection order issued in a lawful way in a jurisdiction that is afforded full faith and credit, and holding that court administrator, the law enforcement responsible to honor that protection order. Next slide. So one more I want to talk about is the Indian Child Welfare Act. And this is one act that many non-Native advocates have very limited knowledge or understanding about. So when we think about the Indian Child Welfare Act originally, so giving some historical context to it, is that we had 100 years practice in the United States of forcibly removing children from their families across the tribes in the United States and placing them in boarding schools. And the intent was forced assimilation. And as a result of that, this 100-year practice, we have generations of people that grew up in institutions. And so they were raised in institutions, basically. And after the end of the boarding school era, or as it was the end of the policy of the boarding school era, we were still seeing disproportionate rates of forced removal, but in a different way of forced removal, where our Native children were being removed from their households and being placed with non-Native households. And my experience, so I mentioned before that I have developed a couple urban Native programs. And in that process, particularly in the one that I worked in American Indian Community Housing Organization, we were in our project, we were fortunate enough, we had a legal project. So we had a staff attorney. And what we were seeing is that children, our Indigenous families and our Indigenous victims were being introduced into the Child Protective Services program rapidly. And what we were also seeing is that there was a rapid movement toward termination of rights. And so children were continuing to be removed. They were being placed in foster homes that were not Indigenous, did not hold the culture of the children. And as a part of that, in a short period of time, a formal process was started to terminate parental rights. And then the children were basically up for adoption. And we still see this today. We still see this all over the place still today. And when we look at the disparities within who is in child protective services and who is being removed, with the percentage of population that we have in our tribal communities being significantly small in the general population, when we look at the representation in child protective services and the removal of children, it's disproportionately high. So ICWA was passed in 1978 as a response to the boarding school era and the continued removal of children. So basically it applies to child custody proceeding in state courts involving Native children, which are basically children of Native American ancestry. And it established procedures for the adoptive or foster care placement of Native children. And it requires that those children, once removed, be placed in homes that reflect their unique traditional values. And so one of the things that the reason this is so important is that we know, working with survivors, for those of you that are advocate programs and those of you that are family-based service programs, that our families tend to be more at risk in that system. And Indian Child Welfare Act basically says that a state, if they are intervening on what they see as a potential abuse or neglect issue, that they need to immediately notify the tribe of origin for that child, so that the tribe has the right to intervene. And in that right, they have the right. So they're an intervening party, and they're entitled to all rights afforded to any party in the proceeding, including the right to sit at council table, the right to examine witnesses, the right to be given copies of documents. And their role is about protecting Indigenous children. So for a victim of domestic and sexual violence, in an urban area, as a person an advocate or a program provider, it's important to understand that, because if you are working with an Indigenous survivor who is dealing with child protective services, immediately that tribe needs to be notified. And recently I was working with somebody where that had not occurred. And as an advocate, one of the things that's really helpful is to help that survivor to make that contact back to that tribe's Indian Child Welfare Program. And all of the tribes have an Indian Child Welfare Program to be responsive to this, and that they should be involved in all court proceedings. They should be involved in the different meetings. They should be privy to all the information of what's going on to protect the children.
So we have a question here. Can civil legal advocates help with the process of having protection orders issued by tribal courts uploaded into the national database?
Actually, I don't have a 100% answer of it. I know that tribes right now, that through OVW and resources that are available to tribes, they have been working with that, and there are TA providers working at helping to put in place systems and connect them to the database. And as a part of that, the tribes are doing it. I don't know if that can happen locally. Let me find out about that after this call, and we can send it out in an email to give you a more complete answer to that, because I think that is really helpful. I think it needs to be entered within the jurisdiction it comes from, but I would say I'm not 100% sure on that.
And then we also have a comment here that says, ensure the ICW workers / staff are aware of the ICWA and get training for those who do not know of the act.
Absolutely. And actually, Hope Wenke, who is our project coordinator for our responses for urban natives, she and I were talking about ICWA, the Indian Child Welfare Act, the other day. And she's actually getting ready to develop some materials. And we were talking about doing some training on it as well to help make sure that that's available. And the critical piece in there is about being advocates in this process. So you need to understand some of just the basics of the law. And as a part of it, the critical piece is the connection back to the tribe. Primarily, so the reality is the way the system is supposed to work is child protection. As soon as they realize they have a Native child, that they are supposed to identify who's that child's tribe and notify that tribe. What we know is that many states are not in compliance on this, or they're doing a really poor job. So yes, training is absolutely critical as a part of it. Yes, and I see Felicia also added, we have non-tribal employees that have zero knowledge of ICWA. Saddens me to hear our kids are not getting the support we all deserve. Our kids are our kids. Bring them home. Absolutely, Felicia. And that's part of why we bring up ICWA here, because people don't always understand that. And maybe someone's heard it, but they don't understand what it means. And particularly when we're talking about domestic and sexual violence, what I know is that our Native women who are experiencing this violence, actually, as a part of it, what happens then is that people react and they say, oh, she's living in a situation where these children are at risk for violence, when we know clearly that a victim is not supposed to be held accountable for an abuser's violence. The abuser is supposed to be held accountable. But yet we see that instead our Indigenous relatives are being held accountable for an abuser's violence. And as a part of it, CPS will get notified. And it can be they can be notified by a neighbor. They can be notified by even advocate programs I have heard have done that, because they have been concerned about the safety of the children, because that person's been with an abuser for a very long time, or a very violent abuser. Instead of looking at the options to help get this person, they quickly activate to moving to trying to get a system involved. And what we know about systems being involved is that, particularly for our Indigenous survivors, is that it may not be the best option for them. Their outcome is going to be different than it will be for our non-Native relatives.
So to answer a question I see here about whether the slides are going to be shared, yeah, absolutely. We can send out the PowerPoint to anyone interested, and this webinar is also recorded, so it will be up on our official Redwind YouTube page within a day or two. So if you wish to fully watch the presentation again, it will be up on there, along with all of our previous recordings.
Thanks, Hanovi. So I want to just tell you a story about a woman that I met. And this was before we developed our local advocate program here, Colorado Springs. So a few years back, and so I've been doing National Tribal TA for a long time. And so a lot of the advocates across the country working within the tribes know me. And because of the training I do, the on-sites that I do, and all of that kind of stuff. And so there was a woman that lived near here. And as a result of her experiences working with a few non-Native programs, she reached back to her home tribe and said, help me, I need to figure something out. So the home tribe advocate knew me, and she basically says, well, Vicki lives in the state of Colorado, and call her. So she gave her my phone number and she called me, and I ended up working with her for a couple of years. My job is National Tribal TA, but I have been an advocate for multiple years before doing that. And I train a lot of advocates. So I just kind of on the side was helping her out. And what I learned in that process was that as a result of some of the lack of information and knowledge of the non-Native programs that she reached out to, she actually, her advocate needs became more complex. So the advocate, the first advocate program, there actually was a custody issue that was going on. And as a part of that, they got an attorney, and the attorney was not knowledgeable about tribal law, tribal authority, tribal jurisdiction, and how that would play out with the children in that local area. And so as a result, while the location of where the mother and her children were living, that court off tribal land had the jurisdictional authority to award custody to the mother. That attorney botched the job because that attorney was afraid to mess up on tribal issues. And as a result of that, that mother ended up losing her children. Not all together, but it was slowly. And as a result of that, the abuser, who was also Native, was going to his homelands and getting custody awarded there. And it was these multiple advocate programs, these non-Native advocate programs, who were doing a standard approach to their advocacy response as if this was a non-Native victim. And it may have been just fine for a non-Native victim, but they didn't understand the unique legal issues that can play out. And then with that woman that I talked to for a couple years, we would spend time talking in the evenings after my workday was done, because I was doing a lot of traveling and stuff. And the other piece in there that I learned from her was that while I could not stop the original mess that was created from the beginning, I talked to her, I helped try to figure out multiple different strategies. We talked to multiple different people, and worked on whatever we could do. And when we came to the end of our time communicating with each other and we were saying goodbye to each other, knowing that we didn't have much more to say, much more to do as we continued forward. One of the things she said was, "You know what, Vicki, you're the only person who has really helped me." And I tell you that because I feel kind of emotional about it as I'm saying it. When I got off the phone and I reflected on it, one of the things for me in the process of working with her was that I felt like I couldn't help enough. I couldn't untangle this mess, and I didn't feel like I was being successful with her. And when I reflected on everything, one of the things she had told me was, "You listen to me." And she had told me that multiple times along the way. "I really appreciate you listening to me." And what I've learned over the years working in urban areas is that, and this isn't true for all of our non-Native programs, but we have within our culturally centered advocate programs, a Native specific advocate program, that we have a different approach to advocacy that is completely engaged with that person. We think about it as a holistic response. We work with that full human being, with what that human being and that household needs, to help them address their safety, to help them to connect to options for their own healing from this violence, to connect to culture, to connect to community, and that we don't send them out there to do it alone. That as that person is supported and connected to community, we are healing our communities in this work. And that's part of why I tell that story, because our advocacy has a different feel to it. So while we have a lot of knowledge that we're required to educate ourselves, to be trained, to put ourselves out there and ask questions, talk to people, but not wait till a Native woman is standing in front of us and then try and figure it out. We need to figure it out well in advance so that that survivor has an advocate that is well equipped. And one thing I do want to say to our non-Native advocates and non-Native providers that are on the call is that I don't expect you to learn about, all aspects of our culture. I don't believe you could. I myself am Dene, and as a part of that, I can't know about everybody's culture. But I have enough understanding about different cultures to know that when I need to ask questions, and I have the resources put in place of who I can reach out and talk to help educate me so I'm ready for that survivor. Because as we think about the survivor, the reason they're reaching out to us is they're reaching out because they're in crisis. They don't reach out to deal with domestic and sexual violence because they're having a good day to day. They're reaching out because something is really big happening in their life, and it's going to have a major life-changing effect on their lives. And so I need to be ready for them. I need to be ready so that they can get the best response possible, so that they have an ability to heal from this violence. The other piece in there that I think is really important, particularly for our non-Native relatives to understand, is that when we think about domestic and sexual violence, for a non-Native response, we are often only responding to the current incident that's happening. And maybe we might be responding to the fact that this particular victim has lived with the violence for multiple years. But for our Indigenous relatives, it's different in the sense that, yes, we're dealing with the current and maybe the multiple years living with the abuse, but we're also dealing with historical and multi-generational trauma that's playing itself out. And it's important for us to have an understanding of that so that we can make sure that we're working with that, as I mentioned, the holistic response, so that we're responding to that person, to what that person needs at this time, and to lay the foundation for the best opportunity for healing in that process. Next slide. So I have this slide on here because when I think about our best options for healing, is really about connecting to our culture. And those of you that are Native specific programs, you're gonna know your resources in your community that you can draw from to help support that survivor to connect to healing ceremonies, traditional medicines, connect to spiritual ways, spiritual healing. And then one of the things that is also important is our language. Our language is going to give us a lot in terms of our strength, and it really is, it carries our spirit within our language, and then our roles within family and the community. And for our non-Native relatives, it would be beneficial to be partnered with a Native program in your area. It doesn't always have to be a domestic and sexual violence program. If you're an advocacy program that's a non-Native advocacy program, there could be another Native organization in your community that's providing a lot of these resources and helping that survivor get connected there, and supporting them to stay and be involved is going to be an important part and go a long way to that survivor's healing. Next slide. And I did want to acknowledge some resources. So there's the Strong Hearts Native Helpline, and that Strong Hearts actually, it has connected to the different advocate, Native specific and tribal advocate programs across the United States. And it also, as a result of being connected to it, so a survivor can call and ask them for help, and they'll talk to them, they'll provide support, do some safety planning, and help them connect to a Native or tribal specific program in their area. And then there's other national resources that can be helpful for looking up information. And some of them, such as NICSA, the National Indian Country Clearinghouse on sexual assault, they have webinars periodically. The National Indian Women's Resource Center has webinars periodically as well that focus on OVW stuff. Next slide. And then I just wanted to mention our training and technical assistance that we have to offer for our urban programs. So this is for our urban Native programs as well as our urban non-Native programs that are working with large populations of Native victims and survivors. So we do one-to-one consultations. We do policy and document reviews. We help people develop their infrastructure. We also do work sessions, and because of the pandemic, we're doing all of that work virtual, but when we can travel, we'll do on-sites as well. And then we have different training options, which includes webinars and conferences and workshops that we can provide. Next slide. So we can stop here and see if there's any questions. Here's our contact information. Under the list of emails is Hope Wenke, who is our project coordinator. So she could be a good resource for you. And then I also put the link for our, to make a TA request. You could either do it through reaching out to Hope or reaching out through our website where we have the web form for making a TA request, which is also the same as this link. So let's just pause to see if there's any questions. And I see, Lucille, that you put in here that you would be happy to work with us as we initiate our ICWA work. And so I will put you on our list because we will most likely be reaching out to you. Thank you for that offer. That's very, very kind of you. Thank you.
Yes. So anyone who is interested in the PowerPoint can definitely get a copy of that.
So we'll send out the PowerPoint, and then there was the follow-up question about the national database for protection orders. So we'll make sure that goes into that email with the PowerPoint. Any other questions or comments or thoughts? So I just want to say thank you so much for being here and joining us today. It looks like we don't have any comments or questions. It's been a pleasure to share this information with you. It really is just the tip of the iceberg. There's a lot more depth that could happen with this as well, thinking about the range of different legal issues that I covered and how that applies locally. And if you want to reach out after the fact and talk about anything specific, definitely feel free to do that as well.
Alrighty, thank you, Vicki. Before we end the session, I want to let you all know that there will be a survey popping up once Zoom closes. We'd love to hear what you thought, so if you are able to fill that out, we very much appreciate it. In closing, I'd like to thank our presenter, Victoria, and I'd like to thank all of you for joining us. I hope you all have a wonderful rest of your day. I hope you all stay safe, and I hope to see you all at the next webinar. Thank you, everyone.
Thanks, Hanovi.